Good afternoon, everyone, and welcome to the Delaware Public Service Commission meeting of April the 5th. We have first the reading of the meeting minutes of March 22nd, 2016. Does anyone have anything to correct or change in the minutes?
Move we adopt the minutes of March 22nd as presented.
Seconded.
Mr. Chair, I have a question regarding the minutes.
Sure.
I think that the executive director mentioned the commission would issue a letter in support of the Telecom Nehru Committee, and I'm just curious, could I get a copy of that letter? Thank you very much. No further questions, Mr. Chair.
Thank you. Any further discussion? Hearing none. All those in favor signify by saying aye.
Aye.
Any opposed? Any abstention? The motion carries. On the consent agenda, we have one item. I guess we can't take it off the consent agenda. It'll be all by itself anyway, right? Anybody have any questions about that particular matter? Tidewater Utilities matter? If not, may we have a motion to approve the consent agenda?
Chair, I move that we approve the consent agenda as submitted.
A second.
Is there any discussion on the motion to approve the consent agenda? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes. The regular agenda, number 1, in the matter of Delmarva Power and Light Company's annual gas cost rate filing. The commission welcomes Ms. Scott.
Thank you, Chair Winslow. This is the order that memorializes the action that was taken by the commission at the last meeting following the hearing that we had on the GCR application. So the parties in this docket work together in terms of the form and substance of the order, and to my knowledge, all parties are satisfied with the contents of the order, and we would ask that you approve it.
Okay, thank you.
Mr. Chairman, as Ms. Scott has stated, you have before you order number 8869 in docket number 15-1355. This memorializes the Commission's decision at the last meeting where an evidentiary hearing was held, and what were temporary rates for Delmarva Power and Light's gas cost rates were adopted as final with a proposed settlement agreement among the parties. Staff also urges adoption of this order.
Thank you, Ms. Mayrack. Mr. Bonar?
Thank you, Mr. Chairman. As indicated in Order 8869, the public advocate has supported the settlement agreement. The form of order is satisfied.
Thank you, Mr. Bonar. Is there anyone else present who wishes to address this matter? Seeing none, any commissioners have any questions regarding proposed order 8869?
Move we adopt order number 8869 as presented.
Seconded.
Is there any discussion on the motion to approve the order? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Number 2 is in the matter of the application of Delmarva Power and Light Company for the approval of the 2016 program for the procurement of solar renewable energy credits. Ms. Scott?
Thank you, Chair Winslow. As you may recall, this is an annual application that is made by Delmarva on behalf of the Renewable Energy Task Force. This application was filed in October of last year. The docket was opened on November 4th. And then there were a number of proceedings going on with respect to the RPS cost cap rules that were in the process of being adopted by the Department of Natural Resources and Environmental Control. So in light of those things that were going on right after the docket had been opened, we had asked that this application be tabled until those rules had become finalized and a determination had been made by DENREC with respect to the cost caps. Those rules now have been finalized, and DENREC has made their determination, which they filed with the Register of Regulation on April 1st. Therefore, we are asking that this application now be lifted from the table and scheduled for its normal evidentiary hearing. We are asking that that be held on May the 3rd.
Thank you, Ms. Scott. Ms. Mayrack?
Mr. Chairman and Commissioners, staff does not oppose Delmarva's request to schedule the evidentiary hearing for May 3rd, 2016, as stated by Delmarva's counsel.
Thank you. Mr. Bernard?
Thank you, Mr. Chairman. The EPA has no objection to scheduling May 3rd.
Commissioners have any questions in the parties regarding the order, or the request, rather? Hearing none, we have a motion to, first motion to untable I've ever seen.
Chair, I move that the commission untable the application, schedule an evidentiary hearing for May 3rd.
I second.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Are there any abstentions? The motion carries. Thank you, Ms.
very much.
Scott. And next is in the matter of the corrective action order issued to Iacona Summer Chase Apartments. Welcome, Mr. Coombs. Welcome, Mr. Coombs, and I guess you're going to tell us, I'm sure, about what a wonderful job that was happening at Iacona, the apartment complex. Sounds like it's doing pretty well, but give you a little bit more time, we understand.
Yes, Mr. Chairman, that's exactly what we've come here to do, is to tell you about the progress to date, answer a few questions that staff has asked us, and then to ask for the extension of time. As the commissioners may remember, in the fall, a corrective action order was given to my client to manage its propane system at its apartment facility. In response to that, we met with staff and came up with a schedule that my client could work under to get the system upgraded. And a further corrective action was entered by the commission to implement that process. We gave a plan to staff and have been working on that since then. There has been some delays in light of weather and also just hand digging in terms of replacing the system. But we sent an update to the staff and have asked for an extension of time in which to finish it. It was to be finished by April 15th. Given some of the delays and some of the hand digging, we originally asked for a delay until June 1st. And talking with staff, and just to be safe and make sure that everything gets done and that staff can have time to then process it and come back and look at it, we're going to actually ask the commissioners today for the extension to go 2 more weeks until June 15th. I don't think that will be opposed by staff. Staff has asked us a few questions as to staffing on the matter. I can tell you that staffing levels have been consistent on it. 4 persons working on the underground lines and then 2 people working on the steel, and that's the subcontractor, and then our contractors had a full-time person on there, and as the weather warms up, they will be able to increase the staff at it. We've been advised that all materials and equipment are on site, so we should have no delays with respect to that. The commissioners may remember there was also a request made by staff to inspect the large tank at the facility. Construction Unlimited did an inspection of that in one place, submitted that to staff. Mr. Platt raised a question about expanding that. We are going to do that to do 3 sides, 3 locations on each side, so that will take some additional time. And as of today, there was 5 phases originally. Phase 3 has been completed as of now, and we're moving on to Phase 4, and Phase 5 are being implemented also.
Ms. Mayrack?
Mr. Chairman and Commissioners, as Mr. Coombs has summarized, staff has been reviewing this process, which you're aware was brought as a part of a routine inspection, and some significant safety concerns were raised the commission issued an amended corrective action order after we had a chance to work with the company and come up with a plan. The commission's options at this point are basically to either grant a reasonable extension of time or to shut the operation down. Staff has personally visited the site, either Mr. Platt or his staff on a weekly basis, and has reviewed the progress, believes that Iacona Summer Chase Apartments LP is complying with the order, has addressed the safety concerns that were there, and that additional time is warranted. Again, the original request was to extend until June 1st, but that offers no cushion for any weather or any other delays. Granting an additional 15 days to June 15th is what staff supports, as Mr. Coombs has requested. Mr. Platt is available if the commission has any questions or needs any more information.
Thank you, Ms. Mayrek. Mr. Bono, you're not involved in this, are you?
No, we're not, Your Honor.
Any commissioners have any questions of the of Mr. Coombs and Ms. Mayrek?
I have a question about the timing. You're saying June 15th, you're saying 15 days. I'm looking at the number 7, page 3, and it seems that the 4 to 5 days actually is taking 15 days. Phases 1 and 2 are complete, so that means phase 3 would be 15 days, phase 4 would be 15 days, and then 10 days for phase 5, and that takes me to maybe the 15th or 20th of May. But is the request till June 1, which is on page 3, or is it to June 15th? And is that really 60 days, or is that 15?
No, that's perfectly fine.
Take me through.
Yeah, the 10 to 15 day periods are working days, so it's 5 days. And you're correct on the timing of it. If everything went smooth and everything went fine, as we originally proposed, it would take it to about that May 15th, 16th time period. There'd be a little more time. After that, we've had the larger tank inspection sort of requests come up, so there's going to have to be some additional work there. And then also just a built-in cushion of allowing the time for my client and staff to finalize and be okay with everything, and for any weather type of delays. The thought was, we don't want to inconvenience you guys more. Just go ahead and ask for the 2 more weeks to go to June 15th.
It'd probably be less expensive for you all to have the additional time, so you don't have to come back to us again and ask for another reasonable extension.
So is the request then June 1st or June 15th? And it was originally April 15th.
It was originally June 1st in my motion, and we're
Okay.
asking for it to be June 15th now.
Okay.
I have a question.
Mr. Conway?
Question for Mr. Platt. You are entirely comfortable that everything is safe there?
Everything they've done so far looks good, yes. Of course, what they haven't uncovered, we don't know about yet. But in their leak surveys, nothing had come up in that area to give us any reason to question anything. So, yeah, we feel good about everything they've done up to this point.
If I could just add on to that, Commissioner, we are continuing to do leak surveys for those parts of the
Yes.
lines that haven't been replaced
Yes.
yet.
Yeah,
Mr.
we're
Correa?
comfortable.
It's a general question to reassure us that there is no imminent danger, there is no possibility of any negative event if we extend this 15 days, is there?
We have not identified any, Commissioner.
Yeah, but as Mr. Platt says, I mean, there are areas that are not yet,
Excavated yet.
you know, you can't explore, so to speak. So, you know, I woke up not too long ago, not today, but a few days ago, and I saw the headlines in the paper. I'm sure the people from the apartment complex, and I said, "Oh my God, I hope that's not these people," because you know. So these, unfortunately, some pretty significant damage can be done to property and people. In fact, one commission member from the California Commission died in a gas pipe explosion in California. So we're very happy with staff and Mr. Platt with respect to bringing this to our attention, and very happy, and also Mr. Coombs and your clients done a commendable job of meeting its commitments to make that apartment complex safe. We hope that ultimately that everything works out very well between now and June 15th. So if we have a motion, perhaps that we might consider giving these fine people a reasonable extension of time.
I so move.
I'll second.
Is there any further discussion on the motion to approve the extension of time to June 15th?
Just one question, Mr. Chair. Is June 15th going to be enough time to prevent that we have to come back to this matter with another decision?
I think it's all the parties' expectation and hope that we would not need to come back, that this would give enough comfort time in terms of any type of weather delays or unexpected issues.
No further questions.
Any further questions?
I second.
Oh, okay. All those in favor of the motion signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Best wishes, Mr. Coons. Okay, the next matter is in the matter of the application of Chesapeake Utilities Corporation for a general increase in its natural gas rates and for approval of certain other changes to its natural gas tariff. Okay, Brian?
Mr. Chairman, Commissioners, Bill O'Brien on behalf of Chesapeake Utilities Corporation. I'm here to introduce our counsel in this matter because he has never appeared before this commission. As you know, you usually see us here with Bill Denman from Schmittinger and Rodriguez. He did pass on this case, so we turn to our counsel in Maryland, who represents us at the Maryland Public Service Commission. His name's Brian Quinn. He's a partner at Venable over in Baltimore. And so he is here to represent us for the rate case and for today's argument.
Good afternoon, Mr. Chairman, Commissioners. My name is Brian Quinn. I'm a lawyer from Baltimore, and I'm aware of the optics here. I know I'm from out of town, and it's my first appearance before you, but I can assure you, and this is on a petition to intervene, and we're opposing that petition to intervene. And we don't bring this appeal lightly. I certainly have respect for your time. I have respect for the time of opposing counsel. And I've represented Chesapeake for over 15 years at the Maryland Commission, and it's not my MO to be an obstructionist at all. But we wanted to bring this to your attention only because we're not quite sure the statutory authority argument I'm going to get to in a minute has been brought to your attention quite in this context. Again, this is a petition to intervene that was filed on behalf of Mr. Coons' clients, who are an association of propane dealers, into Chesapeake's rate case. And we're fully aware that they've been allowed to intervene in the past. But as I said, we're not quite sure this statutory authority argument's been brought to your attention in this way, and I'd like to get to it in a second. The association is concerned with two things in their petition regarding Chesapeake's rate case, and those are two tariff changes Chesapeake's proposing for municipal expansion and for a temporary storage program. They essentially are asking that they be allowed to intervene because they've been authorized to intervene in the past, and why should this be any different? And we respectfully submit that you should maybe reconsider that and take an opportunity now to follow what several other commissions around the country have done and deny intervention to unregulated propane and oil dealers who are not subject to your jurisdiction. They're certainly not subject to the Commission's jurisdiction, who have tried to intervene in rate cases in Maryland, cases I'm familiar with, and in other cases in New Jersey, Pennsylvania, and other states, where those commissions have denied those intervention requests strictly when the intervener, the propane associations, arguments are protectionist of their competitive interest. The only interest the association is concerned with involve our expansion tariffs, and their only impact, the only impact that they're concerned about is that they're concerned that our expansion will hurt the revenues and market share of their competitive propane suppliers, and that's it's fine, and I applaud them for being honest in their reasons for intervening. But what we'd like to bring your attention is that Delaware Title 26, your authorizing statute. We don't see any provision in Title 26 that even authorizes the Commission to consider, let alone protect, the competitive market share of propane dealers in this state. We submit no such authority exists, and the commission should reject the petition to intervene on that basis alone. Before you even get to your intervention statute, which is a two-pronged test, which I'll get to in a second as well, we think their intervention fails the public interest test of the intervention statute, and the second prong, it fails the interest is already represented. Their interests are already, any interest that the propane dealers could bring on behalf of Chesapeake's customers regarding cross-subsidization. They want to find out what the tariff provisions are, how they're going to enter into rate base, all these other questions. The Department of Public Advocate and your commission staff already better represent the interest of Chesapeake customers as relates to those questions. The only real question that they're interested in is how are these tariff provisions going to affect the market share of their members. And by the way, the association has failed to point to any section in Title 26 that authorizes the commission to consider or protect their competitive interests in a rate case involving a regulated natural gas company. Now, the association, in their brief, they say we're not asking the commission to protect its interest, which begs the question, then why are they even in this case if they're not asking this commission for any relief? But nevertheless, no provision in Delaware law even authorizes the commission to consider, let alone protect. This commission shouldn't be concerned in any way with protecting the market share of competitive propane suppliers in a rate case involving a regulated utility. The association argues that your broad statutory authority to review a rate proceeding under sections 201 and 305, they argue that is statutory authority enough for allow you to consider their competitive interest here. They also cite to Delaware Superior Court's case, City of Seaford, and they include a quote from the court about balancing the interest of the consuming public and the regulated utility, which was the product of many years of unhappy experience with the evils of uncontrolled monopoly. I'm sure it's a case you're very familiar with, but the City of Seaford case doesn't support their argument. There, the court was discussing competition between utilities, regulated utilities, not competition between a regulated utility and an unregulated propane dealer. And second, the impact of unwarranted competitive practices. The court was discussing that impact on customers of the utility, not on competitors of the utility. Again, this commission should only be concerned about how Chesapeake's rates and tariff provisions affect Chesapeake's customers, not how they affect a competitive propane dealer who's not subject to their regulation at all. Moreover, Section 201 that they cite, which grants the commission general authority to regulate the rates of a public utility, explicitly authorizes the commission to consider, quote, the interest of the consumer of the public utility service. That's right in Section 201. Section 201 does not contain any specific language that allows the commission to consider the interest of a competitor. It specifically says the interest of the consuming public. Section 305, the last section they cite, is that's a section of law that authorizes the commission to hold a hearing on a rate. I'm not really sure what that has to do with their argument. And it's important to note that when the Delaware General Assembly intends for this commission to consider the competitive effect or the effect of a utility's rate on a competitor, they know how to do it. In fact, in a section of law we cite, Section 708, the Delaware General Assembly authorizes the commission to be a referee in disputes between telecom providers regarding market practices, including predatory pricing. And in there they specifically mention competitive pricing, but in that case, in that statute, it deals with two regulated companies. The telecom companies that statute authorizes you to be concerned about competitive practices, they're both regulated, are all regulated by the commission. It's not the same as a commission, a statute authorizing the commission to deal with a regulated company only. The General Assembly has not provided similar authority as Section 708 in a rate case context that would apply to the propane dealers. And finally, I understand you have a liberal intervention policy, but there's also an equally long-standing policy of administrative law that says that the Public Service Commission is a creature of statute, and it's only authorized to exercise those powers that are conferred by the legislature. So I understand you have a very liberal intervention policy. So does Maryland. So does Pennsylvania. So does New Jersey. The other cases that that have rejected competitive association intervention, because those concepts, those protection of a competitive interest of an unregulated company, is not contemplated by the Public Service Commission law. Now, if you're not buying what we're selling on the legal authority argument, we do also note in our brief that we feel the commission, the association's intervention petition fails the two-pronged test of your intervention rule. As I mentioned, public service commissions in New Jersey, Pennsylvania, we cite the cases in our brief, have all held that it's not in the public interest to allow an association of unregulated propane dealers to intervene in a commission proceeding, in commission rate cases and other commission proceedings. In answer to that, to those cases, the association simply says they don't support our broad assertion. Like I said, those other states, Maryland, New Jersey, Pennsylvania, all have similar liberal intervention laws, all have a very similar intervention rule, a two-pronged rule. Maryland has the exact same rule Delaware does. If your interests are already represented, or if it's not in the public interest to allow the intervener to intervene, intervention is rejected. The association also cites that we have cited, Chesapeake cited to no survey of state intervention policy, which we haven't, so I took their invitation to look a little more at some other states. They're not cited in our brief, and I'm happy to submit on brief afterwards, after Mr. Coons had a chance to look at those citations, if the Commission is all interested. I found that states of Maine, Michigan, Ohio, Washington, and Vermont also similarly do not allow competitive associations to intervene in utility rate cases. The one case cited by the association as support for their argument is an Illinois Commerce Commission case that granted a propane association their petition to intervene in a utility tariff provision case in Illinois. But what they failed to mention is Illinois law contains a specific statute that authorizes explicitly the Illinois Commission to investigate and consider complaints of competitive suppliers. The statute is 220 Illinois Code Section ILCS 5/10/110. So there's a specific law in Illinois that addresses explicitly competitors, unregulated competitors of utilities are authorized to file complaints with the Illinois Commission and participate in proceedings. Interestingly, the Illinois law says that if a competitive supplier is going to intervene in a case, they need to open up their books as well and allow the utility to seek discovery in the competitive supplier's books. But what's good for the goose is good for the gander, obviously, is the concept behind that law. But no such similar law exists in Delaware. Finally, we cite to Senate Joint Resolution 7, which was enacted in 2014, in which the General Assembly and the governor expressed their support for natural gas expansion into Kent and Sussex County. It's attached to our brief. It's attached to the hearing examiner's order. Senate Joint Resolution 7 was signed July 31st, 2014. We submit that's a clear demonstration that the public policy of the state of Delaware is to encourage natural gas expansion. Contrary to Senate Joint Resolution 7, the association's admitted interest here is to protect their competitive market share, which is by limiting natural gas expansion. Rather than addressing Senate Joint Resolution 7, the association attempts to minimize it by saying, well, it's been the public policy of the state of Delaware before 2007 to support expanding gas service. Not really sure how that supports the argument that you should ignore the public policy of the state, but nevertheless, never before 2014 has the General Assembly passed a Senate Joint Resolution in this area. This is the first one of its kind. And Mr. Chairman, once a state senator, always a state senator, I think you have a unique perspective of what a Senate Joint Resolution means. It's the formal expression of the General Assembly of Delaware in support of natural gas expansion. There's a couple of different types of joint resolutions. I looked it up, and the Senate Joint Resolution is the most formal type. And it's a clear expression of the public policy of the state of Delaware to encourage natural gas expansion. And respectfully, the association's only interest in this case is limiting natural gas expansion. Therefore, we argue that their participation is not only not in the public interest, it's contrary to the public interest. All due respect. Finally, the association has made a point that they've been allowed to participate in prior Chesapeake proceedings. First of all, strictly speaking, whether or not they've been allowed to participate in the past is not a prong, it's not a consideration under your intervention statute, so it really shouldn't have any bearing at all. But of course, naturally, the commission is going to want to understand and look at what they've done in the past. And I respect that. But public utility commissions, like any other state agency, they're allowed to change their minds as long as they base that change of policy on a reasonable facts and reasonable argument. They're allowed to contradict a prior policy. That's a longstanding concept of administrative law, even if conditions haven't changed. Now, we submit there are several items that we've mentioned that demonstrate that conditions have changed. I'm not sure anyone's brought this statutory authority argument to you under Title 26 or lack thereof. The number of other state commissions that have rejected association intervention, I'm not sure that's been brought to your attention before. And finally, Senate Joint Resolution 7. We think all those facts, when taken together, provide more than a reasonable basis for you to change your policy of allowing intervention in the past and rejecting the association's intervention in this case. A final point on that issue: the association and the hearing examiner rely heavily on the fact that the association was a signatory to 2 prior settlement agreements, one in Chesapeake's last tariff expansion case, which was in 2008, and then their last rate case, which was, or 2012, and their last rate case, which was in 2008. The fact that they were a signatory to those prior settlement agreements, we feel should have no bearing on their intervention in this case, and let me tell you why. First of all, we're not sure that the statutory interpretation argument or statutory authority argument has ever squarely been put to the commission before. It certainly wasn't put to the commission when they granted the intervention and allowed them to be signatories to those prior proceedings. And we submit that should change the prism through which you view their intervention now. Second, I've read those prior settlement agreements, and the association's only interest in those prior cases was limiting to the greatest extent possible Chesapeake's ability to expand its service offerings. And I can save us all the suspense right here. Their only interest in this case is going to be limiting as much as they can Chesapeake's ability to implement those tariff expansion programs. And again, that interest is directly contrary to Senate Joint Resolution 7. It's directly contrary to the stated public policy of the General Assembly of Delaware, which is to support natural gas expansion. Finally, they do give short shrift to saying the association's concerned with cross-subsidization issues, and they're concerned with rate base and regulatory asset treatment. All of those considerations are concerns of commission staff and the DPA, who already better represent the interest of Chesapeake ratepayers regarding those questions. So although they mention them, I think it's clear that they're really only interested in protecting their competitive market share. And finally, the last thing that the association and the hearing examiner say, and I appreciate your indulgence, finally, the hearing examiner and the association mention time and again that they have a unique perspective to offer on Chesapeake's rate case. Now, they don't explain how being a competitor of Chesapeake, they don't offer any details as to what this unique perspective is, or explain how being a competitor of Chesapeake allows them to investigate a commission or Chesapeake's rate case any better than staff or DPA could. And just because a perspective may be unique doesn't mean it's a concern or even a consideration of this commission. The airline industry or the Boy Scouts of America could offer a unique perspective on Chesapeake's rate case, but that's not the question. The question is whether or not this commission should be concerned at all about the perspective of a competitive propane association in a rate case involving a regulated utility. And so we really think that argument has no weight. And for all those reasons, I appreciate your time and indulgence. For all those reasons, we would hope you take another look at their intervention in this case.
Thank you, Mr. Quinn.
Thank you.
Mr. Coons?
What more could be in this commission's interest and in the public's interest than this commission having a well-balanced, developed record so that it can weigh the service offerings and the other items that Chesapeake asked for in its rate case. That is what this commission is tasked to do, is to look at the lawfulness of rates in a public hearing in a rate case. That's Section 201, and that's Section 305. And that is what this commission has the authority to do. That's its statutory authority. Chesapeake wants to cite to the telecommunications statute that was enacted after the general public utility statutory authority that it has. After enacted a statute that is more specific, doesn't change or somehow offer a different prism to look at what this commission has done over the length of its statutory lifetime. Now, there's a lot of interesting discussions that were made here and a lot of interesting arguments. One of the arguments that they want to make is to follow other commissions. And I think I heard the argument today that all of these other commission decisions that were being discussed were in the context of a competitive association. That's not what I saw from the briefing, but maybe the other case that Chesapeake would like to cite is what they're going to do. I thought that we might hear some new stuff here today, so I went and looked also. And I looked at Chesapeake's file testimony in this case. In this file testimony, a couple of service offerings they want to, they cite to a Maryland commission decision that adopted those. If we look at that docket, it is a gas docket that has a competitor in it, in the proceeding. Now, it doesn't look like there was any argument to try to reject the intervention. But if the Maryland Commission's policy is so clear that competitors are not supposed to be in proceedings, why was it in that proceeding? This commission has looked at in other rate cases. We've talked about arguing other commissions and the ability that you can do to go out and look at and find examples. And for everyone that you can go find on one side, you can go find on the other side. Because there's 51 different commissions at any one time in this country that are weighing things. And then there's FERC, and then there's other authorities. This state has always recognized a liberal policy for intervention. And why? It is to develop the record. It is so that this state can look at and understand what the utility is trying to do, what other services are out there, and whether or not the utility should be engaging in those services. This case is no different. This rate case is no different than the other Chesapeake dockets in which DAEP has historically intervened to look at the expansion service offerings and to offer its, I know that Mr. Quinn would like to belittle the unique industry perspective that we offer, but we do. We are here in the Delaware market. We know what services are being offered. We know what's being done. That is not something that DPA and staff historically look at, and that is not something that their consultants can easily do. We have brought information, we've brought common sense, and we've brought what else is out there to help look at these dockets and look at these proceedings. There was discussion during the argument about Maryland having the exact same rule for intervention. That is not correct. Its test might be the same, but there are different intervention levels in Maryland. So the two Public Service Commission proceedings that are cited in this brief, there is a lower level of intervention that was granted to those parties. We don't have that here in Delaware. You're in or you're out. There was discussion about the Senate Joint Resolution. I think as this commission is well aware, you can go back to 2007, 2005, probably even before then, and find different governmental endorsements of gas expansion. I mean, that's why these dockets, this is why this expansion has been going on, and we have continually intervened. State settlement resolution, I'm not aware if this is the first one or not. It hasn't come up before today. But I know there's been a governor's task force. I know there's a blue ribbon panel that had a similar finding for the expansion service. And yet, we intervened in the next one. There was a settlement as to how the expansion would be done. There's no new optics. There's no new obstructionist nature of my client in this proceeding. You have the statutory authority, and the statutory has always been the same, to consider the lawfulness of any new rate. And the case that Mr. Quinn cited, City of Seaford, that's a Delaware Supreme Court case. And that case recognized that one of the things that this court looks at is unwarranted competitive prices. So to have that information, for you, the commission, to have the understanding, you want the most complete record that you can. If you will, just for a second. The hearing examiner perhaps correctly summed it up when he finds that the AEP's participation as intervener would substantially contribute to each party's analysis of the rather novel service offerings presented in Chesapeake's application in developing the evidentiary record. We don't know what the service offerings are. We have a general idea from what it is, but the specifics are what is developed during the course of the docket. It's that we are interested in finding out how it affects the market here in Delaware and what different services or what different offerings are already out there. And I think that that's what the commission will want to know as well. So, respectfully, DAEP asks that this commission recognize that it has previous dockets, both by hearing examiners and by this commission itself, that DAEP's intervention is in the public interest, that it does have its own interests that aren't represented by other parties in this case, and that it does have the statutory authority to review the lawfulness of rate cases and to have fully developed records for those rate cases, which involves the intervention of all parties. This is not DAEP coming to the commission, as Chesapeake would have you believe, and asking you to protect us and asking you to somehow do something special for us. DAEP has never asked that. We just participate in the record and participate in the docket. Lastly, I would just address the settlement agreement standpoint. Yes, there are multiple settlement agreements from previous dockets that DAEP is a signatory to. One of the things that Chesapeake had to do in this rate case was to file a specific audit based upon a previous settlement agreement with us as to how it's implemented its different administrative requirements. And part of this docket will be to review that. My client should be allowed to do that as a past signatory to a settlement agreement. And it wouldn't surprise me at all if during the course of this docket, there does become discussions about modifications of previous settlement agreements or modifications of previous agreements that have been entered into with DAEP. Why would we not be allowed to be a part of those discussions?
Mr. Coombs, just give me a couple of examples of the positive things your client's going to bring to this discussion about the expansion of natural gas in Delaware.
Mr. Chairman, I think I can look back at some of the things that we've done in the past. In the last extension, or the last expansion docket, we worked with staff and DPA to understand what was the offering that was being done for southeastern Sussex County, and to review the IRRM test that was going to be implemented there. We ran our own schedules for it and worked with staff and DPA to identify what would be reasonable and not reasonable. I think some of the specific offerings that are being made, my client will have significant knowledge of how those markets have existed in Delaware, the need that is generally shown in the market for those. I'm talking about the temporary gas tank. I'm talking about the poultry house offering. Those are things that consultants just can't go out and try to find a simple study and try to find just general information about.
Or we could have a problem with confidential information in this particular docket.
We have not in the past.
And commissioners, any questions? First of all, I apologize. I shouldn't do that. Ms. Davis, are you speaking on behalf of staff on this matter?
I am. My understanding is that staff is not taking a position on this matter.
Okay. Mr. Bernard?
I wasn't going to make any comment at all, but listening to both attorneys talk and realizing that I am not an attorney, I will speak only as the public advocate and as a layman. I think my position as the public advocate has been clear during my term of office thus far. Anytime you have intervention in a case by outside individuals, it ends up being costly to consumers. And my role as the public advocate is to protect the cost of consumers. Who pays for the intervention by the association in this case? It would be the Chesapeake consumers in the long run, not the propane consumers. That being said, you all know as members of the commission that I have also expressed a desire in the past to see public participation in all of our cases. This is, after all, the Public Service Commission. And the question that you as commissioners have to answer is whether or not staff and the public advocate are capable of representing both the association membership and the consumers who will ultimately pay for this that are customers of Chesapeake. So those are the decisions that I think you as commissioners are going to have to make, and I as a public advocate have to go by your wishes.
Any commissioner have any questions of the parties? Commissioner Correa?
If the situation was other way around, and if you were asking for something and Chesapeake came or any other regulated entity came to us and say don't allow you to do that or allow you to do that, you would possibly come back and say, we are not regulated, do not tell us what to do. Will that be the case? Am I
Commissioner Correa, I believe I understand your question to be, would we participate in discovery, or maybe that's one part of your question, and the second part of your question is, would DAP's constituents submit to the authority of the Public Service Commission? I think you can say in the latter, they wouldn't, because you don't have statutory authority for them. They're not a public utility. But in terms of the discovery that goes on in the cases, we as a party are subject to reasonable discovery. This is not the first, for lack of a better word, this is not the first time that these issues have been discussed, have been considered. The discovery of DAP has been before previous hearing examiners. It's been before, I don't know if it's been before the commission before or not, but our role in these has been before the commission before, and DAP has always in the past, reasonably conducted discovery as appropriate. Now, most of the discovery goes the other way, but most of the discovery still conducted by staff and DPA. You know, I don't think this is a case where you're going to see us running up the discovery trying to find these. We're interested in a very small subset of a much larger rate case.
Mr. Quinn, I guess it would probably be appropriate to ask if you have a couple more minutes of argument you want to make.
I'll be very, very brief. You've listened to me long enough, and I appreciate your patience. First thing, Mr. Coons mentioned the different intervention levels in Maryland. It's true. We have the same prong for an intervention test, which is public interest or whether or not issues are already adequately represented. In Maryland, you could be a full party, or you could be what's called an interested person, which means you just are allowed to receive the filings on the service, like you're on the service list. Mr. O'Brien tells me that, in fact, in Delaware, you do have those two separate statuses. You do have a full party status, and several years ago, he found a case where you do allow interested person status, which is just allow, for example, you would allow the association to be on the service list, to receive all the official filings, including discovery in the case, as an interested person. I'm told, I'll go on record as saying if we can brief the commission afterwards, but Mr. O'Brien assures me that that is allowed here in Delaware, and I'm happy to.
Well, the hearing examiner addressed that in his paper, and you didn't appeal it. I mean, the hearing examiner says, however, this commission has interpreted its intervention rules as full, unless just cause to otherwise occurs after intervention is granted.
Mr. Coons, excuse me. You said that there was no two levels in Delaware. I said that there are. That's all I said.
That's right.
Okay.
The hearing examiner did not recognize those two different levels.
Okay. And then I appreciate that. And then I heard, Mr. Chairman, your question was spot on as to, what will you add by your participation in this rate case? And I think everything I heard Mr. Coons say is already represented by the DPA and staff. It's not the commission's job to explain our filing to the association. It's not important for them to understand our filing. It's of no it's no concern whether or not they, as competitive propane dealers, the only people that need to understand our filing are staff and the Department of Public Advocate and you, the commissioners. Again, it's a concern that this concern about just developing a full record. Yeah, we could allow the Boy Scouts, the airline industry, we could allow any party to come in to develop a more fuller record. But that's not the question. The question is, should you be concerned with their interest at all in this case? And we argue that you shouldn't be. Out of respect, I'm not saying they haven't participated before. I didn't impugn call them obstructionists at all. We're happy to work with them. It's not my MO to be an obstructionist, and that's not why we're here. We were just respectfully here to bring this issue to your attention. That's all we're saying. I just don't think the commission needs to be concerned about an interest that isn't covered by its statute. It's an interest that is obviously contrary to Senate Joint Resolution 7 and the other public policy of the state. And respectfully, as citation 201 and 305, I've already addressed that. 201 has some explicit language that says your concern is with the impact on customers, not competitors, and 305 doesn't have any language at all that's relevant. In any event, I'll rest on that. Thank you, Mr. Chairman, for your time. Thank you.
Thank you, sir. Ms. Mayorek, do you have any comments you want to make with respect to the argument?
Just as Commission Counsel, to clarify, I think it might be helpful, as the Commission knows, we have an electronic docketing system called Delafile, and maybe that's some of the confusion about whether Delaware recognizes two levels of intervener status. Certainly, any member of the public is able to subscribe to a docket, and that is done on the website without any involvement of a hearing examiner of this commission or conferring any official status of intervener or otherwise. So any member of the public could subscribe to any of our dockets, including this one, and be alerted when filings are being made, and then have access, as any member of the public does, to any of the public filings. But intervener status, there's really, once status as an intervener is granted, there's only one status, and then that party has status as an intervener and on all the rights and privileges that go along with it. So I think there's either the public website option to subscribe to a docket and receive those alerts, which again involves no official legal status, no involvement by any authority with this commission, or else intervener status. And I think that the question before the commission today is whether to affirm the hearing examiner's order, which granted intervener status on DAAEP, or to vacate it. And the parties have briefed the legal standard that to intervene a party, it needs to be in the public interest and have interests that are not adequately represented by another party, and that's the decision before the commission.
Mr. Chair, do you mind? Same question to both Mr. Quinn and Mr. Coons. Do you agree that this intervention will cost Chesapeake customers money? Mr. Quinn first.
Well, yes, Commissioner. It's going to cost us additional rate case expense to go through the time and effort to respond to discovery requests from the association. It's going to take additional rate case expense to respond to any arguments made in the briefs filed by the association. If they proffer witnesses, it's going to be rate case expense for me to review and cross-examine those witnesses at an evidentiary hearing. Anytime you add an additional party to a case with full rights of discovery and presentation of evidence and witnesses, that's something the utility will have to respond to. 3 is more than 2, so we will have to respond to more than just staff and the public advocate. We're going to have to respond to any discovery requests and evidentiary proffers and witnesses that the association decides to make. So yes.
Thank you. Mr. Coons? Same question.
I don't disagree with Mr. Quinn that an intervening party in the general matter will cause some expense to the public utility. However, there is some efficiency also that can be brought by DAEP participating in this document. It has knowledge that on the market, on what is offered here in Delaware, that others will not, and that for you to have a full record, you will then have to task either your staff or somebody at the DPA to go find out for you. So it does present an efficiency also in bringing information to this commission. And I should say that the question of cost has been considered by this commission before. And in order number 7325, previously allowing DAEP to intervene, the commission said, furthermore, the hearing examiner can minimize the litigation costs caused by DAEP's intervention by disallowing discovery from DAEP that is unrelated to its interest in this case or that is otherwise unduly burdensome. So, I mean, that's what we have to live with.
Two follow-up questions, Mr. Coons. So is it your opinion that the value of these efficiencies is going to exceed the cost to the customers?
Yes.
And one last question. In what ways will working with staff and the DPA not allow you to achieve your goals in this matter?
Because staff and DPA's interests are different than DAP's interest and different than what it can present in a hearing or to this commission. With all due respect to DPA and staff, and I work with them a lot, and I know them, but I generally know what their interests and where their, what their arguments lie. And that won't necessarily be aligned directly with DAP's.
If the staff, sorry for interrupting, if the staff's interests are the public interest, then how and in what ways do your interests differ from theirs?
Well, we are part of the public, but we are not the public as a whole.
No further questions. Thank you.
I have one question.
Commissioner Korea.
there's a considerable discussion about regulatory assets and the rate base and how it affects the rates and what have you. On page 6, it is your point that Chesapeake or any other regulated utility may create an asset not including the balance sheet, then when the right time comes in, include that in the rate base and bring it back in the balance sheet. Now, usually, the independent CPA firms and the IR and the tax people will not allow bringing asset in and out, as and when you and I think, or they think, and anyone else thinks. Even $100, if I bring it in my personal income tax, if they catch it, there'll be a problem. So here we are talking about large amount of rate base and regulatory asset. So bringing it in the balance sheet is not only like against the basic accounting principles, but then outside watchdog like CPA, independent CPA. You have independent CPAs, right?
Yeah.
And IRS, of course, will not just allow you to have, hey, 10 million here and take it out, and then next year we'll add it here. That may not happen as easily as is printed on this. Would you explain us your logic of saying that?
Well, anything that I put in here was based upon what Chesapeake had in their application. And I think that will be part of the discovery as to how they intend to put it into their rate base, or what basis they would have for it, or how they would justify it, or what type of regulatory asset they might ask for this commission to allow them to set up, and whether or not that would be justified by what the service offering is.
Then would you explain us how can you bring an asset 1 year and take it out despite CPAs and IRS and what have you? Please?
Yes, Mr. Commissioner, there is a concept that's called a regulatory asset, and if it meets certain rules, it's part of what the FERC form. There's rules around when you can do deferred accounting, and so what a regulatory asset is you take certain investments, you put them in a deferred account. They can accumulate over more than 1 year, and then they are then rolled into rate base at a later date when they're used and useful. At the time they're rolled into rate base, at that rate case, then there's a full review, prudency review. There's a full review of what went into the regulatory asset, and then and only then, after it's been reviewed by staff, DPA, at that next rate case, is it allowed to be rolled into rate base. It could be rejected. In other words, we put stuff in the regulatory asset, shouldn't be in there, it can be rejected at that time. The rules governing a regulatory asset, though, are strictly written by, it's a FERC, I forget the citation to the rule, but there's a rule about, in order to be put in a regulatory asset in the first place, you have to have some instance of assurance by the commission that it would be approved. You can't put a controversial item into a regulatory asset. So this will all be explained further in the course of the rate case. But that's generally how it works. It's this deferred accounting mechanism, and then it's put into rate base at a later date, only after it's been reviewed for prudency by the commission.
If we deferred the decision in this matter, would it have an adverse impact upon the parties?
No, Your Honor. Thank you.
Although I would remind the commission that the rules require a decision within 30 days, or it's deemed denied by operation of our regulation. So we would need some action if the commission wishes to avoid that outcome today.
Process question, Mr. Chair. Is this the evidence you're hearing on the 14th of April for this matter?
Nope.
No, it is not.
Okay. Thank you.
For our next meeting is within the 30 days.
Well, the petition for interlocutory review was filed on March 16th, and the next meeting is April 19th. So that would not be within 30 days.
We're happy to waive any statutory 30-day requirement if it's at all necessary or useful to staff.
That may be an issue as well.
Can I even do that?
We've often asked ourselves that question.
Yes, yes, sir.
Well, the one, you know, I guess, if I recall correctly, in the past, I guess we're taking some action as we sit here. We took the action of listening to you all, getting educated on the issues. Okay. Does any commissioner have any thoughts about what to do in this particular matter?
From a historical perspective, Mr. Chair, it seems like we've had a fairly liberal policy of allowing intervention, yes? And we have an order in front of us, 8860. I would move that the commission adopt Order 8860 as submitted.
Just to clarify, the hearing examiner has already issued Order 8860. So the commission's decision, I guess to maybe rephrase the commissioner's motion, would be to deny the interlocutory petition and let that order stand.
Understood. So I will adjust my motion to deny the interlocutory appeal and allow order number 8860 stand. Is that the correct motion?
That sounds perfect.
I'll second it.
Okay. I would like to thank Mr. Quinn because I don't believe we have heard the argument you made today. Maybe I'm wrong, I could very well be wrong, but it's the first I recall having heard the argument, and I think it's a sound argument. On the other hand, as Commissioner Gray has stated, we have in the past fairly liberally allowed people to intervene, whether that's good or bad is a matter of some disagreement. And I guess in this particular case, I believe that you're, in a general sense, arguing that there are competitors, and so therefore, you know, they don't bring the appropriate tools to the table, so to speak. On the other side, though, Mr. Coombs is saying that they have some unique perspective, and that there are some unique things about the marketplace and some of the aspects of the marketplace that the public advocate and the staff are not knowledgeable in, but they are knowledgeable in. So, although I find it to be a pretty close case, and I don't find that cost has anything to do with it. I don't think that's in the statute. Any statute you point to, I don't believe cost is a factor. So I guess where I am, I'm impressed with that argument. But on the other hand, because of our historical basis that Commissioner Gray has referred to, and because of the arguments made by Mr. Coombs on behalf of his client, that there are some unique factors, novel aspects of this case, I'm going to go and vote positively to Commissioner Gray's motion. However, I do believe that what the commissioner should do is to keep in mind this issue and keep a sort of an eye out as to how this litigation goes and see if our decision in this matter was perhaps one we should reconsider the next time around. So that's my thinking on this particular matter. Anybody else have any comments they want to make or any discussion? Mr. Gray.
One comment, Mr. Chair. Mr. Coons, I would hope that if the commission accepts affirmatively this motion and your interlocutory engagement in this matter moves forward, that one principle you will keep in mind is to make sure that what you bring to the table for the proceedings is with and for the public's interest, as Mr. Quinn has argued, that the competitive interest is not really what would be appropriate under the circumstances.
Is there any further discussion? Looks like there's none. All those in favor of
Mr. Chairman, was there a second on
Yes,
the
there
motion?
was.
Yeah.
Okay, thank you.
Commissioner
Sorry.
Currier did. Is there, all those in favor of the motion to deny the interlocutory appeal and therefore uphold the order issued by the hearing examiner below, All those in favor signify by saying aye. Aye. Are there any opposed?
Opposed.
Are there any abstentions? The motion carries.
Thank you, Your Honor.
Thank you.
Thank you very much, Mr. Quinn.
Thank you.
You mentioned optics, so I put my glasses on to make sure I could be okay. Okay, the next matter is in the matter of the defining good faith effort to make payments for water, gas, and electric utility customers with certified medical conditions. This will be Ms. Mayrack.
Yes, thank you, Mr. Chairman and Commissioners. You have before you in docket number 16-0295, proposed order 8873. This is a request by staff that the Commission open a docket, which would be an investigation into utilities' current practices in the application of 26 Delaware Code 117D. This statute is what allows for if a customer has difficulty making payments but has a medical condition which would be adversely affected by cutting off water, gas, or electric service, that medical condition would be adversely affected. So it requires that the utility not terminate service. In 2012, there were significant revisions made to the statute by the General Assembly. This was House Bill 261, because it was discovered that there were some customers who were taking advantage of this program well past the medical need in not paying their bills. Of course, when some customers don't pay their bills, those costs are then absorbed by the rest of the ratepayers who are paying their bills. So the General Assembly in 2012 adopted House Bill 261, and what this did was change the procedure for how this certified medical condition was handled. And in this case, a utility customer with a certified medical condition gets an initial 120-day period. At the end of that 120-day period, they must renew the certification, so they have to renew so that their service is not terminated. But they also have to show that they are making a good faith effort to make payments. The statute did not define what a good faith effort to make payments means. It permitted this commission to promulgate regulations to define that phrase. This commission has not yet promulgated those regulations. So 4 years after the change in the statute, we still don't have a definition of what a good faith effort to make payments means. Staff would like to undertake an effort eventually to come up with a definition, but at this point staff lacks enough information about how the utilities are applying this section of the statute. And as you can imagine, we expect to find some variation in how the utilities are applying this. There have been several customer complaints. We've also received some outreach from the governor's office about how this is being handled. So staff would like the commission to open a docket so that staff can conduct an investigation, which would involve 2 public workshops that would involve soliciting information from the utilities about their current practices, about the number of customers who are impacted by this, also give any customers who are in this program or impacted by it, as well as any community groups that may be out there that represent low-income customers who would be impacted by this program, to come forward and give feedback. Staff would then report back to the commission with our findings, and then hopefully use that information to eventually come up with a regulation defining this term. So staff would ask that the commission adopt order number 8873 and allow us to go forward with this investigation.
Thank you, Ms. Mayrack. Mr. Bonar?
Thank you, Mr. Chairman. We had suggested this some time ago in discussions with staff and between Mr. Howitt and myself, and we're happy to support this.
Thank you, Mr. Bonar. Any commissioners have any questions? Mr. Commissioner Correa?
I would request that the staff would also look into the practices of other states like New Jersey, Maryland. They may have defined already and provided examples of good faith efforts or payment efforts. So that will make like additional your job a little more easier and more balanced. So
Yes, and I believe I neglected to mention that, but that is a part of our petition. It would be to look at current practices, to solicit public feedback, and then to also look at what other jurisdictions are undertaking. So
Mr.
thank you.
Glennar?
Thank you, Mr. Chairman. Mr. Perry, the resources of both NASUCA, the National Association of Consumer Advocates, and the National Association of Regulatory Commissioners are fully able to meet the needs of all of this, and will be utilizing their research arms as well. So,
May we have a motion with respect to proposed order number 8873?
Move we adopt order number 8873 as presented.
I second it.
Is there any discussion on the motion to approve order 8873? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Are there any abstentions? The motion carries. We're going to take a 5-minute break.
Thank you.
5-minute recess.